I'm here with Shaun Pascoe of Pascoe Criminal Law, which is a new criminal law firm based in the centre of Melbourne. And thank you, Shaun, for coming on and having a chat to me. Being a criminal law practice, which we don't have as many of on Firm Checker, got heaps of questions, which will be really interesting for the end user, and which is always a bit more juicy than the typical corporate and corporate and commercial stuff. So welcome and thanks for coming on.
Thank you, Ben. And look, thanks very much for the opportunity. Much appreciated.
It's great to have you on. So just to get started, maybe you could give us a rundown of the types of criminal law matters that you've traditionally worked with. Obviously, my understanding is you've had a fairly broad experience, which keeps things interesting. Maybe you could tell us a bit about that.
Yeah, certainly. So my experience in criminal defence work encompasses all cases that are dealt with in the Magistrates Court, but also our Superior Court, so the County and Supreme Court. Within the work in the Magistrates Court, I deal with any prosecution case. So that can be local council prosecutions, it can be prosecutions brought by Victoria Police, but also Commonwealth agencies. So it really is all things criminal defence related. The bulk of criminal matters that are dealt with in Victoria are dealt with in the Magistrates Court, and so quite often, and certainly before all the restrictions that are in place now, I would be in court on a daily basis dealing with a variety of cases. But I've also always had an indictable practice, which would see me in the county court for far more serious offences. So it's varied, which is what I enjoy. The work it takes in a variety of different types of cases, as I think I've just mentioned, motor vehicle offences, people that are concerned about losing a driver's licence, those types of cases that are routinely heard in the Magistrates Court, but also the more serious cases that I've just referred to. So a very, in a sense, broad mix of work, but it's a specialist criminal law firm, so I obviously don't do conveyancing or those other types of civil cases. Some work that I've been doing a lot more of in recent years is responding to and assisting clients defend intervention order matters, both personal safety intervention order matters and also family violence intervention order matters. And there's, particularly with the family violence intervention order matters, there is a little bit of a mix between the civil side and the criminal side. And so often with family violence intervention order matters, there is a crossover or an interplay between the civil side, so the actual making of an intervention order and what that comes with that, but also with the potential for criminal charges resulting from that initial intervention order.
And just, does your firm straddle both the civil and the criminal side, or do you say, focus on just the criminal and then partner with other firms for the civil?
Yeah, that's a really good question. In relation to intervention order matters, and particularly family violence and personal safety intervention order matters, those types of applications are strictly speaking civil applications, although they're quite often brought by police on behalf of an affected person or a protected person, depending on the type of application. But it's often important to liaise closely with other specialists. Take, for example, family violence intervention order matters. Those types of applications, if they're not dealt with carefully, can have implications for concurrent family court proceedings. And so the way that an intervention order is dealt with, and particularly at the early stages, as to whether the approach is to contest the intervention order outright or whether it's better to try and consent with some negotiations. They're very important considerations because it can have a bearing on say, a custody dispute involving children, and particularly where there's an allegation of family violence as part of one parent's application against another for increased contact. So quite often in my work, as part of receiving instructions to assist someone for a family violence intervention order matter, I'll liaise with some experts that I know personally and professionally that can also assist in ensuring that the client is looked after, not only from the criminal allegations side of things, but also family law aspects of the case that are equally important. So yeah, there is that, particularly in the area of intervention order matters, and particularly with family violence intervention order matters, there is that overlap between the criminal law jurisdiction and family law.
So you mentioned negotiations, and if we're confining that to the criminal law specifically, what are the sort of factors that you typically consider if you have a defendant, for example, who is subject to accusations or allegations of family violence?
Yep.
What would make you negotiate with the prosecutors, for example, and what would be the factors that you're considering in that circumstance, with negotiations, with guilty pleas versus non-guilty pleas, etc.?
Yeah. Certainly. So I guess the starting point is that a client will make contact with my firm, and then we offer an obligation-free consultation where we will typically have some paperwork that they've received from the police. It might be a charge and summons, it might be the application for an intervention order. And then there'll be some preliminary instructions obtained from the client about essentially what their version of the allegations is. And it might be that it's just a complete denial of all the allegations, or it might be that the allegations are asserted to be much more serious than they actually were. So quite often there'll be a factual dispute about what's alleged to have taken place. After that initial consultation and following signed instructions to act for a person charged with a criminal offence, the next stage in the process is to attend court. And if we're dealing with the magistrate at the magistrate's court level, where most offences are dealt with, that starting point will be to attend a case conference. And the case conference is the earliest opportunity to discuss with the prosecution areas of their case which are either deficient or so lacking, just completely lacking in evidence, and also to convey my clients instructions about what they say happened. So that's the earliest stage for direct negotiation with the police. At the moment, because of the restrictions on face-to-face contact between defence practitioners and the police, you can't meet them in a room and have those discussions. So increasingly, that sort of negotiation process is happening online. It's happening, I should say, online, but through email communication or telephone calls. So you're still having a negotiation process that approximates what you would do at court, but it's happening through emails and phone calls. At that point, and as a result of those discussions, the prosecution may have cause to rethink their case. And it might be that as a result of what's conveyed in that discussion that they decide to withdraw all charges, or they decide to withdraw the most serious charges or downgrade charges to a less serious offence. If there's no agreement, then the case then proceeds to the next level, next stage of the litigation process or the criminal proceedings, and it's listed for what's called a contest mention, which where again there's further discussion and there's often an opportunity to receive further evidence from the police and to discuss that with the client. And then ultimately, if as a result of continued negotiations it's not possible to get to have the police withdraw the allegations, or at least to withdraw the most serious allegations, then the case ultimately has to be listed for that third stage, which is a contested hearing, where all the evidence is placed before a magistrate, the prosecution present their case, and the accused has an opportunity to defend the allegations. They might decide to give it evidence themselves or not. And at the end of that process, and after all the evidence has been received by the court, a magistrate then decides ultimately whether an accused is guilty or not guilty of the offences, and that's the final stage of the outcome. And hopefully, if it's contested, they're found not guilty. If they are found guilty, then there's an appeals process to the county court. So yeah, that's kind of a snapshot of, I guess, of the process from start to finish when dealing with a criminal offence. It's obviously more to it than that, but that's an overview, I guess.
Well, I think that's a pretty helpful overview for anyone who's listening and who doesn't necessarily know a great deal about criminal law. If we're zooming out and looking at, I guess, a cross section of all of that process, how long does that typically take for different types of matters? I mean, perhaps you can break it down by specific offences,
Yeah.
but yeah, how long are people looking at for that? Because it's obviously a pretty big impingement on your life if you've been accused of a criminal offence.
Yes, that's a good question, Ben. Look, it really depends on the offence. For minor, if you're dealing with really minor speeding infringements, which to be honest, I don't do a lot of those incredibly minor infringements, but that the start date from that might be wrapped up within, if it's contested, it might be wrapped up within 3 to 4 months. It would be relatively easier to get a hearing date fairly soon after that first listing. And that's because typically those sorts of cases, they're typically 1 to 2 hour cases. If someone's gone through a red light, they call the police officer that's involved with the incident. An accused person might want to have their say and give evidence. It's types of hearings that are usually wrapped up within the space of an hour or two. So it's a lot easier for the court to find time for that type of a hearing because it's so the facts are really simple and the evidence isn't going to take too long to be brought out and adduced into court. In other cases where the allegations are more serious, it can take much longer to have a case resolved, and particularly if it goes through those stages that I referred to before, because after a contest mention, if the case is still disputed, a court has to be told how many witnesses are going to be required for a case. And if there are anywhere from sort of 10 to 15 witnesses, then it might be that a contested hearing date occurs over or is run over 2 days. And so the court then has to find time in a really busy court diary to run a 2-day hearing. So getting back to your question, in that sort of situation where there's it's a serious allegation, let's say it could be an allegation of stalking that's occurred over several months, multiple witnesses involved, and multiple actual individual instances that are also part of the charge. And so that might end up being a 2 to 3 day hearing. It could take anywhere from sort of 9 to 12 months for that sort of a case to be resolved. And that's in the magistrate's court. The county court, it takes much longer than that. So for pleas of guilty, obviously where a case where the facts are fairly simple, there's not much dispute about what's occurred, that type of case can be finalised either on the first listing of the case, so the very first day the case is heard. That would usually only happen where it's relatively straightforward and the client says, you know, what the police have said about what's occurred is what occurred. I've got no dispute with the facts. That type of case can be heard on the very first listing of the case. More often, there'll be matters that are in dispute and that are important to dispute, and where it's a negotiated plea over what is admitted and not admitted, and you're trying to sort of minimise the damage and try and get the best result that you can within the parameters of essentially accepting most of the facts, then that type of case might be resolved at a second hearing. So between anywhere from sort of 6 to 8 weeks. So at the highest end, it could take 12 months or more to get that final hearing date. But it really depends, and certainly depending on my client's instructions and what they want to achieve, it's certainly possible for it to be a lot dealt with a lot sooner than that as well. So it really does depend on those things.
Well, I think you finished on quite an interesting point. It does depend on your client's instructions. Do you find that for lesser offences, people are perhaps happy to swallow their pride, even if they don't think something is right, and just take it on the chin because it is such a lengthy process?
Yeah, there's a real tension between a client having their day in court and just fighting a case on the principle or fighting a case on the basis of what's really important for them, which they always have the option to do. And so there's that option of just say, well, I want my day in court. I want the court to hear everything about this particular case. I want them to hear my side. And on the other hand, there's the pragmatism and balancing up what are the risks of running a case and losing against getting something that's more certain. So there's always that tension between, and of course, the longer a case goes on as well, you can't ignore that there are cost implications. So there is always that tension between being pragmatic, and in some cases, you can advise a client, well, it's unlikely that that you'll lose your license in this particular way, or you've got the opportunity of a court diversion, or there can be other benefits that come with dealing with the case on a non-contested basis. On the other hand, of course, sometimes it's critically important that a client has their say in court, and so as part of my role is to inform them of their options and the benefits they have in doing one thing over the other, or to the benefits in pleading guilty as opposed to running a contested case and losing. But the decision always rests with them, and I've been doing this for many years, and there's always that tension between a client having the opportunity to absolutely convey their version of what's occurred, as opposed to the benefit of resolving a case in a way that doesn't unduly cause them a lot of expense, but also still achieves the result that they're after, which might be avoiding conviction, it might be retaining their driver's license, it might be avoiding a criminal record through a process such as diversion. So there's a number of things to take into account. But ultimately, once I provide my client with all of that advice, I follow their instructions and act on their instructions. So the choice always rests with them.
Yeah, well, that obviously makes sense. And we've been speaking about things in terms of like a high level and the whole process of, being charged through to all the way to your final hearing date and having the case resolved. I want to zoom in specifically on the point in time, which is probably one of the most stressful points for, I imagine, any of your clients, which is being arrested in the first place or being charged with an offence. At that point, do you have any advice for listeners on what you shouldn't do and mistakes that you see clients make?
Certainly. So at the point at which, so a client is and this goes for whether a client is arrested and immediately taken into custody, or whether they receive a phone call from the police and with an invitation to go to a police station for an interview. The most important aspect of the process, and particularly in regards to what a client might decide to do ultimately with an allegation, is what they say and how they conduct themselves at that police interview. So my advice to clients, and whether that's speaking to clients on the phone or at a conference or receiving a call from the police station, is that in almost every case, the most important thing to do in Victoria, other states may be different, but certainly in Victoria, is to exercise their right to give a no comment interview. Now that's really important because at that stage of the interview process, the police are in a lot of respects so much better prepared for that side of things than the client is. They've got professional training in interviewing suspects. They're familiar with the process. And a client is always at a disadvantage, and it gets worse if the allegations are dated. So my advice when receiving that initial call, either from the police station, or someone might be family or might be the police officers themselves that say, look, we have this person in custody, he's requiring legal advice. And after asking them some preliminary questions about the nature of the allegations, my advice inevitably is to give a no comment interview. And that's not telling a suspect, a person who's accused of an offence or who's in custody, that to be uncooperative. The police in Victoria have to advise a person before they interview them in relation to an offence that they have the right to give a no comment interview. Giving a no comment interview means that once all the evidence is in, once statements have been prepared, once items of evidence have been obtained by the police and are part of a brief of evidence, or at least a preliminary brief of evidence, then a client can go to their lawyer and say, this is a document that I've received, this is the prosecution case against me, what should I do, what would you advise me to do? And a client in that situation is able to make an informed decision and get informed advice from their lawyer about how to properly respond. If the decision is to plead guilty after receiving all of that advice, then the client loses nothing in terms of the ultimate penalty. They still get the benefit of a plea of guilty, but they're making that decision on the basis of informed advice from the lawyer. So probably there are exceptions. There are exceptions to giving a no comment interview. One exception might be, for example, where self-defence it's important to raise that at the earliest opportunity. But the exceptions are fairly limited, and in almost all cases, it's important to preserve a person's ability to respond appropriately to an allegation by giving a no comment interview. And my experience is that a lot of people that are in that situation where they're interviewed, particularly for the first time, believe that if they just sort of tell the police their version, if they can somehow just persuade the police that they're right, that it'll all go away and that the police will see it their way and that'll be the end of it. It never happens that way, and they're always better off in that initial stage giving a no comment interview. Police will not refuse bail on the basis only that a client's exercised their right in Victoria to give a no comment interview. Other factors come into play in terms of bail and whether a person is released from custody. The deciding factor, there's several, but if the offence is incredibly serious, then they won't be released from the police station. Large commercial drug trafficking, for example, offences relating to assaults causing serious injury and the like, and are offences for which the police are able to keep a person in custody, and a person in that situation has to make an application for bail in court. So there are circumstances where a person will remain in custody, but that's because inevitably that they might have a terrible criminal history, failing to answer bail in the past, or the offences are just so serious and the law requires them to remain in custody until a judicial officer, such as a judge or a magistrate, releases them. But they're the factors that determine largely whether someone remains in custody before making a court bail application, not whether they gave an interview or not. So I guess that's my sort of advice in terms of police interviews and what to say to police after a person's been arrested.
Yeah, that's really interesting. And I've got two questions that come out of that for me. One of them is something that's perhaps, it seems very silly given that you've said it's a no comment interview, but how would you go about exercising your right to a no comment interview? Is it purely a case of staying completely silent, or is it literally saying no comment a bunch of times, or saying I'd like to speak to a lawyer first? What's the best way to go about that? Yeah,
certainly. As part of the interview process, there's a number of cautions that the police must by law explain to a person. So typically if a person attends a police station purpose of interview, they'll be placed under arrest for the purpose of that interview and then taken into an interview room. They'll be explained as a kind of an induction process or reception process for dealing with a police station interview. Once that's finished, the interview will start and there'll be advised that the interview is recorded. Sometimes there's the ability for interviews to be video and audio recorded. So there's a recording of that. They then have to set out the rights an accused person have. So they literally have to read out the legal rights that a person has in responding to and participating in that interview process. And as I said before, one of the important rights that they must tell a person about to be interviewed is that they do not have to answer the police questions, and that's effective. That's confirmation that an accused person has not only should but has the right in Victoria to give a no comment response. And just getting back to your question, how does a person actually do that? There are some questions that the police are required to ask a person that deal with their identity and their ethnicity or Aboriginality. There are certain questions that they must ask, and an accused person can tell the police their name, their age and their address, all of those matters that are formalities and go clearly to confirming on as part of the interview process and on tape that the person they're interviewing is the right someone else. So those questions can be answered. Once those formalities are dealt with, it will become obvious that the interview will then sort of transition to asking questions about, usually in an open-ended manner, about what happened on a certain date. And the idea behind those sort of open-ended questions is for the accused person, the suspect, to volunteer and to have a conversation about what's occurred, because that's how the police get evidence about the allegations that they're aware of. So an accused person in that situation should indicate to the police that they intend to answer the questions no comment. And sometimes it really is a situation of saying after that initial question, no comment. And the police don't automatically stop after that. They can continue to ask questions about the allegation that they're interested in. And an accused person should, as silly as it might sound and as uncomfortable as it might feel, answer no comment to each and every question that follows. What is critically important is that a person who is decided that they will answer no comment doesn't change tact and then all of a sudden start answering questions that they feel are harmless or aren't going to are not controversial. And the difficulty with that is that once the interview is finished, if they've answered some questions no comment and chosen to answer others, then it comes across that they've been selective in their answers, and that decision to answer some questions no comment but answer others can be utilised by the prosecution at a later stage if it goes to trial. Or as part of the contested hearing process, it can be pointed out to them that, well, you gave a no comment response to these questions, but you decided to answer these ones. What are you hiding? So a no comment, a decision to give a no comment interview means that a person gives a no comment response to each and every question that's asked, even where an interviewer might say, well, listen, we're just doing our job, and we have to ask you these questions, and we just want to get your side of what occurred. Even when presented with those types of comments, an accused person should still say no comment. It might be that several questions are asked, and if the response is no comment, that the interviewers say, is it your intention to answer all of our questions no comment? And if the response is yes, it is, I do intend to answer these questions no comment, then the interview terminates, and that's the end of it. Sometimes, in a lot of cases, a person accused, if they've received advice, shouldn't feel shy about saying to the police, I've received advice from a solicitor. My solicitor, his or her advice is to answer your questions no comment, and I'm going to act on that legal advice. If they feel if they feel more comfortable saying that they're actually doing it on the basis of legal advice. It really doesn't matter whether they do that or not, but the important thing is to be consistent and to answer every question, no comment, even if they feel uncomfortable doing it. And the police, for their part, it's not an unusual thing to do. The police, experienced investigators will have encountered hundreds, if not more, occasions where a person gives a no comment response. So it's nothing unusual for them.
And do you find that have you found that police have strategies to try and get people out of saying no comment answers, like what you said with, we're just trying to do our job, ways of putting subtle social pressure on people to be more discursive?
Yeah, look, it's the questions are typically dealt with and asked in an open-ended manner. So at all points, and they receive training, and some investigators are quite skilled in investigative techniques. But the idea is to keep the suspect talking and for it to be conversational. So oftentimes there are appeals to just help us do our job, or we just have to put these allegations to you, and so it's not uncommon at all for the police to continue with certainly at least putting the allegations to an accused person, even in response to no comment responses, because the more information that they can obviously get from the accused person about what's occurred, the easier it is for them to investigate it. And the interview process is just one of many, is a really important part of the investigation, because through putting allegations squarely to an accused person, they get information potentially that they wouldn't otherwise have. And in a lot of cases, inadvertent admissions, being caught out in giving incorrect information or lies can really assist the prosecution and ultimately being successful in their case. And quite often, in my experience, what might be thought to be a well-meaning admission or acceptance of responsibility for one seemingly minor aspect of a prosecution allegation or prosecution case can take on far more important consequences and ramifications later on. So it's being mindful that the police investigators have a job to do. The investigation or the interview is an important part of the investigation. It's something that they're required to do. They're after as much information as they can. It's not an opportunity to convince, particularly at that stage, the investigators as to the person's innocence, and a person going into that with that sort of a mindset is just simply not the right thing to do. There is that attempt to have an accused person provide information and participate and to answer questions, notwithstanding some early responses of no comment. And it's quite common for several or more questions to be asked, or the entire set of allegations to be asked of the person in response to no comment responses. So they might go through everything that they intended to ask that person and ask every question that they wanted to ask, notwithstanding someone has said no comment. And they just need to be aware of that.
I think that's really helpful information for anybody who's listening and does find themselves in the situation where they are subject to a police interview and allegations. I could stay on this particular topic and drill down into all kinds of nooks and crannies for a long time, but I'll actually change speed in the interest of time and just get to more current events. Obviously, there have been some changes in the law with stage 4 lockdowns in Victoria. Is that something that you've had any experience in dealing with, or is there any sort of high level advice of things that people need to be aware of that they may not be aware of just through reading the news, etc.?
Yeah, look, I haven't had many direct calls in relation to some of the fines that have been issued for stage 4 breaches, for not wearing a mask, for example, or for being outside the curfews. People might be aware there are a number of restrictions that have been escalated in the last few weeks from the stage 3. The website, I suppose, which has a lot of information in terms of the stage 4 restrictions, would be the Department of Health and Human Services website. They have all the directions issued by the Chief Health Officer in Victoria published on that site. The law in regards to failing to comply with the directions, so failing to, for example, be at home during curfew, failing to wear a mask when leaving home, all of those sorts of restrictions that are now put in place, there is a reasonable excuse defence. So upon receiving I guess in terms of the fine and that sort of process, upon receiving an infringement, a person has a number of options. They can either say, all right, well, fair enough, I did the wrong thing, I'll pay the fine. Or they might say, well, I'll pay the fine, but I need time to pay, in which case they would go to the Fines Victoria website and they'd either apply for an instalment order or an extension of time to pay. Or they might ask the police to review the decision. And as part of that application to review, they might refer to either exceptional circumstances or special circumstances. So there might be particular and compelling reasons why someone found themselves in breach of one of those health directions. And the police are required to conduct a review based on the reasons why that person feels it's unfair that they pay the fine that they've received. The police don't have to successfully, they don't have to agree with a review. It can take a number of months for the police to conduct a review. If the review is unsuccessful, a person has the ability to take it to court and contest it. There's obviously a cost-benefit analysis to be undertaken there by that person in terms of whether they self-represent, whether they pay a lawyer to represent them. The fine, as I understand it, in Victoria is $1,652 or at least $1,600 for an infringement fine. One of the risks, I suppose, in taking to court is that they might have to pay more. There might be some statutory costs that are included by the court if the person is still found to be in breach. So there's an additional expense that is sometimes associated with contesting a case in court. And importantly, when a person receives that infringement, they usually have 21 days in which to do something. So if they do nothing, if they don't apply for a review, if they don't say, well, I want to contest it in court, then that can have an adverse consequence insofar as it costing more money, because the longer it sort of goes on unpaid, the more expensive it can be, and there can be, as I understand it, certain enforcement measures that the government can enforce for non-payment as well. So I hope that provides a bit of information. As I say, there's certainly a lot of information online in regards to what the restrictions are, and also in terms of applying for through Fines Victoria in terms of extensions and time to pay. But insofar as a possible defence, it's reasonable excuse, special or exceptional circumstances, and they're the three areas, I suppose, that one might look to if one was going to try to fight a fine.
Well, that's really helpful advice for anybody who, doesn't really know their rights and doesn't know what that process looks like. Just to sort of wrap up the interview, I'd like to talk about the formation of your firm and, running the business itself. You're obviously a very experienced lawyer, having been a partner at a major criminal law firm in Melbourne for a number of years. What motivated you to go out and start your own practice?
Yes, look, it's a good question, Ben. As you said, I was a partner for many years with one of the largest specialist criminal defence firms in Victoria, and really, for me, it was an exercise in self-fulfilment. I had been very comfortable doing things my own way and doing the same type of work for a number of years. And I really wanted to forge my own path, do things a little bit differently, have some more control over the type of cases that I dealt with. And going out on my own really afforded me that the freedom to do those things. So it's been a very, it's been both, I keep telling people, it's been both exciting and daunting, this whole process, because doing the day-to-day law side of things has come second nature to me. But the other skills that I've had to develop and still learning to develop will take some time. But it's been good to stretch myself and to develop, I'm hoping, a new skill set and sort of meet all the challenges that come with establishing any sort of business from scratch, and a law practice is no different. So, and really the focus for me is to develop a practice which is focused on developing a high level of service for clients. It's not in my thinking to develop a kind of churn and burn practice which has an enormous file load and is solely about high volume and churning out a high volume of cases in the shortest period of time. As I say, the focus for my business is to really provide a high quality level of advice and representation, if that means for a smaller group of clients. So it's really, from my point of view, quality focused.
And what have been, I'm sure the challenges are numerous, because running your own business means that you have to be across every part of it goes into running a business, and that can really hit you like a ton of bricks when you first start out. But what would you say is the single biggest challenge for you as a lawyer in terms of having to brush up on new skills?
Yeah, it's the certainly trust accounting was an aspect of running a practice that I had no direct involvement with. So the sort of the financial side of things is obviously incredibly important and very important and onerous responsibilities on a principle in terms of the financial side of things. Marketing and marketing for myself as a practitioner, as a business owner, is something that I've never had to focus as much on previously. So that's been something new to me. Building a sort of a website from scratch was an interesting experience, and I've never had to do that before. So there are new areas that I'm enjoying that are separate to the cut and thrust of going to court every day for a case, and which has been really good. And somewhat ironically, that the whole COVID lockdown business at the moment has meant that I've been able to spend more time getting things set up than would otherwise be the case. So the sort of the increased hours at home has in an odd sort of a way been a bit of a benefit as well. So yes, there have been a number of challenges that but I've been enjoying them to date, and it's been overall, it's been quite a positive experience so far.
And have there been any resources that you might recommend to other people who are considering doing the same thing and defecting from a larger firm and going out on their own? What have you found most helpful in terms of the resources that are available to you?
Look, oddly enough, if you just get on get on a computer and funnily enough, like YouTube's actually a good resource for a number of different things. So there's a lot of information out there. The important thing is just to sort of utilize what you can online, and there's an enormous amount of information that's just on the web itself. But I'm still if you ask me again in sort of 6 to 12 months' time, I might have something more to say about that, because I'm still learning myself, and there are a number of things that I've had, like a legal practice management software, for example. That's something that I've had to sort of get my head around and learn about. There's a number of things at the moment, because the business is so young, that I'm still learning. So I'm sure that in 6 to 12 months' time, that that will have more to say about certain courses or certain activities that I wasn't aware of, that I'm now aware of. And like anything, you sort of, it's a trial and error thing, and no doubt you learn from your mistakes. So I'm really at this point in the sort of the early sort of learnings of how to operate and run a business. So yeah.
Yeah, well, I think you shouldn't discount what insight you can give, because it was actually, I first heard it from the founder of a project management software called Basecamp, which is really widely used around the world. It's a huge company now, but the founder of that company, he said that actually the most helpful people to talk to about starting a business are people who have just done it, because they're just looking at the tools that are new right now. Whereas if you're talking to somebody who ran a startup 10 years ago that's now an established company, the tools available to them at the time were very, very different. So,
yes.
And also the methodologies and the ways of thinking. So I guess my final question would be, if you had one piece of advice to somebody who's looking at going out on their own, whether it's through corporate or criminal law or any type of legal practice, what would that piece of advice be?
Look, I'd say just to back yourself, and people will know whether they feel ready to take that step, and to get as much. I suppose what I'm trying to embrace is just to get to speak to as many other people as I can, and get as much advice as I can about all sorts of things. So talk to people that know a bit about, that have been there, and can of course offer their own experience, and find out as much as you can. It's and be open to trying different ideas that you wouldn't have previously have involved yourself in. But importantly, just to back yourself, and to embrace the challenge that comes with doing something completely new, and getting out of what for me was at least a very comfortable sphere, and I just didn't know that I wanted to keep doing the same thing. So it's certainly been challenging, but also there's a sense of excitement in what the future holds, I think, as well.
Absolutely. Well, Shaun, it's been great to talk to you. It's a really exciting new project that you've got going on at the moment, and the advice that you've been able to give to end listeners who might find themselves, in a position where they're being interviewed by police, for example, I think has been very helpful. So I'll let you get back to your day, but really appreciate it.
Thanks, Ben. You're most welcome. Thanks again.
Thanks.